This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome! We're diving into a really crucial topic for any aspiring solicitor, exactly how damages are calculated in tort law. We're going to break it all down with a laser focus on what you absolutely need to nail for the SQE1 exam.
You know, this quote, it really cuts to the core of what we're talking about today. It's from the Association of Personal Injury Lawyers, and it's just such a powerful reminder that this area of law isn't about winning some kind of lottery. It's about the impossible task of trying to undo a wrong and restore a person's life.
And that brings us to the single most important principle you have to get your head around: compensation. Every single rule, every calculation we are about to look at, it all flows from this one fundamental idea: using money to try and put the injured person back in the position they were in before the harm happened.
So here's our game plan. We'll start with that core principle, then build on it layer by layer, moving into how it all works in practice. This should give you a really solid framework for your studies. All right, let's jump in.
Okay, so just to hammer this home one more time, our starting point, our North Star, is that the goal is always compensation. It's not about punishing the defendant. The entire system is built to provide a remedy for the harm someone has suffered.
Right, let's get into the nitty-gritty. All compensation gets split into two main buckets, and it's absolutely vital you can tell them apart. They cover completely different kinds of loss, and crucially, they're calculated in different ways.
Okay, so here's the key distinction. General damages, well, they're for the things you can't really put a price tag on, right? The actual pain, the suffering, not being able to enjoy your life the way you used to. Special damages, on the other hand, are for everything you can stick a number on: lost wages, medical bills, travel costs, you name it. Think of it as the human cost versus the financial cost.
So for general damages, we're talking about pain, suffering, and loss of amenity. You'll see it shortened to PSLA. And then special damages cover all those financial hits, both the ones you've already had and the ones you're going to have in the future.
Now we're wading into what can feel like deep water, calculating future financial loss. But honestly, don't be intimidated. It's a very logical process, and we're just going to take it one manageable step at a time.
So this is the magic formula you need to know. The multiplicand is just the net annual loss. So, for instance, what someone would lose in salary in 1 year. You take that number and you multiply it by the multiplier to get that final lump sum award. Simple as that.
But where does this multiplier number come from? Well, the answer is the Ogden tables. These are the official government-issued actuarial tables, and they are an absolutely essential tool, both for lawyers in the real world and for you trying to ace this exam.
And that brings up a really important question about fairness, doesn't it? I mean, if you give someone a huge chunk of cash today that's supposed to last them for decades, they're obviously going to invest it, and it's going to grow. So, how does the law stop them from being overcompensated?
The answer is something called the discount rate. It's basically a percentage that gets applied to the whole calculation to shrink the lump sum down a bit. It accounts for the investment returns the claimant is expected to make over their lifetime. It keeps things fair.
For your exam, you'll need to know the current rate. As of early 2025, it's a positive 0.5%. And because it's a positive number, it has the effect of lowering the total compensation, working on the assumption that the claimant will earn a positive return on their investment.
So here's the process in 4 simple steps. 1, you figure out that annual loss. 2, you find the starting multiplier in the Ogden tables. 3, and this is the step people always forget, you have to adjust that multiplier for real-world risks, the chance of being unemployed anyway. And finally, 4, you do the big multiplication.
Okay, now that we've got a handle on future losses, let's switch gears and look at the specific rules for the tragic situation where a tort actually results in someone's death. You need to know about 2 completely separate types of claims here, each under its own act of parliament.
It is so important to keep these two acts separate in your head. The Law Reform Act claim is brought for the deceased, by their estate, covering the suffering they went through before they died. The Fatal Accidents Act claim is totally different. It's a claim brought by the dependents for their own losses because of the death.
Now, under that Fatal Accidents Act, there's also this fixed bereavement award.
The amount is set by the government, and it's only available to a really narrow group of people, like a spouse or the parents of a minor.
Let's look at a really important case for the Law Reform Act. In the awful case of Hicks, which came out of the Hillsborough disaster, the House of Lords made a tough decision. They said that the terror the victims felt couldn't be compensated. Their reasoning was that because there was no physical injury before death, there was legally no pain and suffering for the estate to claim for.
But that principle was fine-tuned in the more recent case of Shuza. Here, the court decided that if a person experiences intense fear in those moments right before a fatal physical impact, that fear can actually be compensated as part of their pain and suffering. It's a subtle but really important distinction from the Hicks case.
All right, enough theory. Let's see how this all works in practice with a question.
Okay, have a think. Remember the cases we just talked about, especially Hicks, and think about the core principles of the Law Reform Act claim. Who is making this claim and for what exactly?
And the correct answer is C, nothing. This question is a direct hit on your understanding of the Law Reform Act. The estate can only claim for suffering the deceased person actually experienced. If the death was instant, there was no period of suffering, so there's nothing for the estate to claim under that heading.
Okay, let's bring it all home with a quick recap of the essentials and a quick warning about some common trip-ups. You might want to get ready to screenshot this next slide for your revision notes.
So here it is, your final checklist. Always keep that core principle of restoration front and center. Know your general from your special damages. And for goodness sake, please do not mix up the fatal accident acts. As a final thought to leave you with, think about that bereavement award. Does a fixed sum, available to so few people, really live up to that core principle of fair and just compensation? It's definitely something worth thinking about.